Good morning, everyone. Good morning or good afternoon, depending on where you are. Thank you for joining me today for this complimentary 1-hour webinar on FMLA essentials and real-world solutions. I'm so glad to have you here today. My name is Elga Lejarza. I'm going to be your presenter today. And yes, that's me. And I do have all those certification credentials after my name. I like to collect them. I prepare a lot of HR professionals to pass their HR certifications. So I have boot camps for all these HR certifications. And I've been in human resources for many years. That's why I have all those certification credentials. I'm still missing a couple of more. I'll give you my email address if you have any questions. I'm giving you the company phone number. I would like to ask you to follow me on LinkedIn and up to between connections and followers up to 50K. I want to get to 100K. Yes, 30 years in human resources. Well, officially on January 1st, 2025, in about a month, I'm going to have 30 years in HR. Not enough, because I definitely want to make it to 50 years. I want to be the first HR professional to be in the World Guinness Record with the most years in human resources. I'm the founder, CEO of HR Training Classes.com, HR Develop, and Lejarza HR Consulting. Before we get started, I'd like to let you know that I'm not an employment law attorney, but I'm as knowledgeable as the best employment law attorney. I have always been fascinated with employment laws, but I need to let you know that when I give a recommendation and advice, it's based on what I will do if I will be in your shoes. This is going to be a 1 hour. I may just go a little bit over 1 hour because I have a lot of information to share. This is the agenda. We're going to be looking at FMLA essentials like eligibility requirements, cover reasons for FMLA, employer responsibilities, and then we're going to spend a little bit at the end going over some real-world solutions, some FMLA complex situations. Well, let's go ahead and get started. So FMLA. What was FMLA enacted and when was enacted? It was enacted on February 5th, 1993. So it's close to being 32 years old. And FMLA was enacted on February 5th, 1993 to allow certain FMLA eligible employees to be able to take time off for family reasons and medical reasons without fearing losing their jobs. So when somebody goes on an approved FMLA, the employee is going to be able to come back to the same or an equivalent position. So that's one of the protections with FMLA. Restoration job protection to come back to the same or an equivalent position. When we say an equivalent position, it's going to be one that is going to be almost identical. And I'm not just referring to the same hours, the same pay, the same benefits, but I'm also referring to very similar, almost equivalent duties, tasks, roles, responsibilities, functions of the job, status, privilege, have to be very, very equivalent to the original one. Because if we lower any of these things as we bring back the employee, we could be facing a retaliation claim. The two types of claims that we need to avoid at all costs with FMLA are retaliation claims and interference claims. Well, this is why FMLA was enacted, to allow certain FMLA eligible employees to be able to take the time off. Not just having job restoration rights, but the other thing that it is protected by FMLA is the employee's group health insurance. So if the employee has group health insurance, medical, dental, vision for the employee and for the employee's family members, when he or she goes on FMLA, they're going to be able to maintain the group health insurance. It's not going to be for free. Nothing is for free. but the employer and the employee will agree on how the payments are going to be made, how the employee is going to be responsible to make the payments for their premiums. Some employers will work with the employees and will wait until the employee comes back to work and starts receiving the regular paycheck for the hours worked to get the payroll deductions from their check to pay for the premiums. So that is called catch-up contribution. Some employers are going to tell the employees that the employees are going to be responsible to pay for the portion of the premiums as they are taking FMLA. So that is pay as you go. FMLA is enforced by the Wage and Hour Division of the Department of Labor. It's part of having knowledge and understanding which laws are enforced by the EEOC, which laws are enforced by the FCCP, by OSHA, by the Department of Labor. So FMLA, as well as FLSA, are enforced by the Wage and Hour Division of the Department of Labor. So this is one of the protections, as I mentioned, under FMLA: job security, job protection, job restoration right to come back to the same or an equivalent position, continuation of health insurance, medical, dental, and vision. When the employees are approved to go on FMLA, the employees are going to be able to be out up to 12 weeks during the same 12-month period, up to 12 weeks. For most of the FMLA qualifying reasons. Now, there is one FMLA qualifying reason in which the employees, they could be out. They could be out up to 26 weeks, and that is the military caregiver leave. When an employee needs to be out to care for a family member who was injured during military service. The military caregiver leave is the only one in which employees can take up to 26 weeks in a 12-month period. All the other FMLA qualifying reasons are only up to 12 weeks in a 12-month period. But this one, military caregiver leave, is up to 26 weeks in a 12-month period. This one is also the only FMLA reason in which employees can take FMLA, not just for their immediate family member, which are the ones typically covered, for example, spouses, parents, son or daughter. That is a family member under FMLA. Well, for military caregiver leave, the family member extends to what is called next of kin, KIN. And this is a blood relative from the employee. Don't be surprised if you have an employee who comes to you and says, I need to take FMLA for my brother, for my sister, for my nephew, for my niece, for my granddaughter, for my grandson, for my cousins. Oh, yes. We cannot deny FMLA for military caregiver leave for any blood relative. And here's the thing, if you say, well, I didn't know. That's why I told the employee that that relative was not covered. That's why I deny FMLA. Well, you could be facing an FMLA interference claims because you interfere with the employee's right to take FMLA. And even if you said, I'm sorry, I didn't mean to do that, I didn't know. You know what the courts are going to say? You knew or you should have known. This is when you're going to find that ignorance is not going to be your best defense. So by saying, I didn't know, that is not really going to help us. All righty, so first let's start with who is an FMLA covered employer, because not all the employers are going to have to provide FMLA. So in the private sector, a covered employer is one that has 50 employees within a 75 miles radius in the current or in the preceding calendar year. So let's say that you have one building, and in your building, you have 50 or more employees. There's only one building for your company, but you do have 50 or more employees, and you are in the private sector, okay? Then you are a cover employer. How about if you only have one building for your entire company, but you have less than 50 employees? No, then you are not an FMLA cover employer. So for example, I have a total of 7 employees. I am not an FMLA cover employer because I only have 7 employees. That's in the private sector. So what about if you have several locations? So in one location, you have 10 employees. In another location, you have 20. In another location, you have another 10. In another location, you have 20. Well, if you have 50 employees or more within a 75 miles radius, 75 miles north, south, west, and east, you account all those employees within a 75 miles radius. And if you come out to at least 50 employees or more, then each of those locations are going to be cover employers. In the current or in the preceding calendar year. So what do we mean? So let's say that this year, 2024, you have 60 employees. No, let's say, well, yeah, let's say that we have 60 employees. And let's say that next year, because of financial difficulties, competition, etc., you only have 45 employees in 2025. Are you going to be a cover employer in 2025? You have 45 employees. Yes, you still will be a cover employer. Why? If you only have 45 employees, because in 2024, the previous year, you were a cover employer. So you always look at not just in the current year, in the current calendar year, do I have 50 employees or more? If you were a cover employer the year before, because you did have 50 employees or more, then you're still a cover employer. But that's in the private sector. How about in the public sector? How about public agencies, including local, state, federal government employers? How about public, private schools? It doesn't matter how many employees you have, you're always going to be a cover employer with public agencies, public and private schools, regardless of the number of employees. How about joint employers? Let's say that you have employees from a temporary agency who have been working with you for a long time, maybe even years. Okay, so who are they going to be eligible for FMLA? They could be, yes, eligible for FMLA from both employers, from the staffing agency and from also the employer that they are working with. So that is a cover employer. A cover employer, again, is one that has 50 employees or more within a 75 miles radius in the current or in the preceding calendar year. Well, now let's look at who is an FMLA eligible employee. What are those FMLA eligibility requirements? Well, number one, we look at the length of service. In order for somebody to be able to take FMLA, they need to meet 3 eligibility requirements. Is the 3 of them, is that 1 or 2? They need to meet the 3 eligibility requirements. The first one is that the employee needs to have at least 12 months of service in the company. Those 12 months of service, they don't have to be consecutive, but they definitely need to be within 7 years. So let's say that you are rehiring an employee. You're rehiring an employee within 7 years from when they left. Well, when they left, they have 2 years of service, and now you rehire them. Because you are rehiring this individual within 7 years, you're going to give them the credit of the 2 years of service that they already have with you. Okay, so that means that they meet this eligibility requirement when you rehire them. How about if when they left within 7 years, they had 10 months of service? Okay, Then when you rehire them 2 months later, they're going to meet this eligibility requirement. But that's just one. They need to have 12 months of service. As you can see, they don't have to be consecutive, but they need to be within 7 years. Another FMLA eligibility requirement is that the employee must have worked at least 1250 work hours within the last 12 months. Within the last 12 months, the employee minimum needs to have 1250 work hours, meaning regular and overtime. Those are work hours. No, we are not going to add PTO, sick days, holiday, funeral days. No, we are going to be only adding regular and overtime hours. And if the employee has at least minimum 1250, 1,250 physical work hours, then they meet the second eligibility requirement. Well, they also need to meet another eligibility requirement, which is they need to work for a cover employer, right? One that has 50 employees or more within a 75 miles radius. The employee could have 12 months of service. The employee must have worked 1250 work hours in the last 12 months. But if the employee doesn't work for a cover employer, then they are not going to be able to meet FMLA eligibility requirements. Let's look at the FMLA qualifying reasons. What are the reasons employees may need to take FMLA? Well, we have what we call traditional reasons, but we also have military-related reasons. What are the traditional reasons why an employee may need to take FMLA? Well, they may need to take FMLA for their own serious health condition that makes them unable to perform their job. This employee who needs to take FMLA because of their own serious health condition, if the employee meets FMLA eligibility requirements, the employee is going to be able to take up to 12 weeks in a 12-month period. 12 weeks in a 12-month period for the employee's own serious health condition. They can take up to 12 weeks to care for a family member with a serious health condition. They can take up to 12 weeks for baby bonding, to bond with a healthy new child or a child that they adopted or a child that they are taking under foster care. That is up to 12 weeks in a 12-month period. I'm not saying that they can take 36 weeks in a 12-month period. It's not that up to 12 weeks for their own serious health condition, up to 12 weeks for a family member with a serious health condition, up to 12 weeks for baby bonding. No, it's a total of no more than 12 weeks combined. So they can have different FMLA requests, but the employee cannot take more than 12 weeks of FMLA in a 12-month period. So those are the traditional reasons, but we also have military reasons why the employee may need to take FMLA. One is called qualifying exigency. It's also up to 12 weeks in a 12-month period. This is when the employee is going to have to take time off on their FMLA to attend meetings, events, activities that are going to be related to the deployment overseas of a family member. Meetings, appointments. So up to 12 weeks in a 12-month period. Now, there's one more related to the military, and this is the military caregiver leave. This is the one in which the FMLA eligible employee can take up to 26 weeks in a 12-month period to care for a family member who was injured during military service. This is the one that I mentioned that extends not only to the parents, spouse, son or daughter. This is the one that extends to any blood relative, next of kin. Don't be surprised, again, if you have an employee asking to take time off under FMLA to care for their cousin who was injured during military service. We cannot interfere with employees' rights to take FMLA. Okay, so employees can take FMLA for their own serious health condition or for a family member with a serious health condition. So these are the different definitions of a serious health condition. Inpatient care, chronic condition, conditions requiring continuing treatment, permanent, long-term condition, pregnancy, and prenatal care. Do you know that a woman who is pregnant, even if it's a normal, healthy pregnancy, it is said that the employee has a serious health condition that is called pregnancy. So the employee who is pregnant doesn't need to have any medical conditions related to pregnancy, such as sciatica, preeclampsia, gestational diabetes, depression, carpal tunnel, anemia, heart problems. No, they don't need to have those medical conditions. Just a woman being pregnant under FMLA, that means that that woman has a serious health condition. And if the employee wants to take FMLA, even for prenatal care, to go for doctor's check-in visits, the employee, if the employee meets the FMLA eligibility requirements and provide you the paperwork, we cannot interfere with the right to take FMLA. We're not going to be able to say, no, you cannot take FMLA. You have a normal pregnancy. Doesn't matter. That person has a serious health condition that is called pregnancy. And also for multiple treatment, that's also another serious health condition. Maybe the employee needs to attend multiple visits for chemotherapy or multiple visits for maybe dialysis. Now, it's not that difficult anymore. With the new forms, the new FMLA forms, the certification of healthcare provider for the employee's own serious health condition or for a family member with a serious health condition, they have this list, just like you see it over here, of serious health conditions. So the healthcare provider, the physician, is going to have to check which is the serious health condition. Is it inpatient care? Is it chronic condition? Is it conditions requiring continuing treatment, et cetera, et cetera. So they're going to check which one is the one that corresponds to the serious health condition. Please note that we cannot require the healthcare providers to give us the diagnosis. No, that will be you're interfering with an employee's FMLA rights. So we cannot request or require the healthcare providers to give us diagnosis. All they have to do is check one of these serious health conditions, and that will be sufficient. So who is a family member under FMLA? As I mentioned earlier, spouse, parent, and son or daughter. So who is considered a spouse under FMLA? Includes husband or wife, defined under state law, including same-sex spouses, and also including common law marriages, where they are recognized. Common law marriages, very old concept. When couples didn't have transportation, so they couldn't go and apply for a marriage license, and they would just agree that they wanted to present themselves as a married couple. So they will get married. No paperwork, They don't have to get a marriage license. They don't have to go in front of anybody and ask them to marry them. This is just a mutual agreement. Very old concept. Now, we still have about maybe 7 states that recognize common law marriages. South Carolina, where I reside, used to be one of them, but they stopped recognizing common law marriages on July 23rd, 2019. What does this mean? What it means is that if we have employees, for example, here in South Carolina, stating that they got married before July 23rd, 2019, they are married. If they said we marry under common law, they are married. If they said that they got married after July 23rd, 2019, then they are not married, because that's when South Carolina stopped recognizing common law marriages. Okay, so why is this important when it comes to FMLA? Well, I want you to imagine an employee who used to live in Texas. The employee got married to their significant other in Texas under common law. But now the couple, the married couple, moves to Florida. Florida doesn't recognize common law marriage anymore. They did many years ago. But anyways, sometimes the employees, I don't know why, they like to mention, oh, I'm married under common law. And I'm thinking, okay, why are they sharing this with me? To me, this is irrelevant. They are married or they are not married. I don't want to know how they got married, right? But sometimes they like to mention that. Okay, so here you are in Florida. One of your employees who mentioned to you, I'm married under common law. And now the employee is asking for FMLA because the employee's husband or wife is going to have a serious health condition. It's going to have a surgery, and they're going to need also recovery time. So what do? What is that HR person supposed to do? Is the HR person going to deny the FMLA request because the employee mentioned that they get married under common law and Florida doesn't recognize common law? No, you are not going to deny it, because common law marriages are legal marriages. That's a legal marriage. They got married, it's legal. And it doesn't matter where they go. It doesn't matter that they move to an state that doesn't recognize common law. They're still married. When we say that an state doesn't recognize common law marriages, such as Florida, what that means is that residents in Florida cannot marry under common law. They don't recognize that. But if you have a couple who states that they can marry in another state under common law, then they are married and you have to accept it. You cannot deny to the employee FMLA rights to care for the husband recovery. We cannot interfere with employees' right to take FMLA. So those are spouses. How about parents? Parents include biological, adoptive, step, or foster parents, even step parents. However, parents-in-law under FMLA, which is a federal law, parents-in-law are excluded. It also may include individuals who acted as a parent to the employee. When the employee was a child, and there's this individual or individuals who acted as the parents to the employee. So that means that that person acted in loco parentis, taking care of the child like if they were their parents, because their parents were not in the picture. Maybe the parents were in jail. Maybe the parents were living in another country. So we have this person who is taking care of this child. in loco parentis, acting as the parent. And here's something interesting. They don't need to even have biological relationship to have somebody that they are acting in loco parentis. And then we have who is considered a son or daughter under FMLA: biological, adopted, foster, stepchildren, as well as legal ward or children from who the employee stands in loco parentis. So don't be surprised if you have an employee who comes and says, I need to take time off to care for one of my nieces who is going to have a serious procedure. Don't be surprised if you have an employee who says, I need to take time off to care for my neighbor's son who is going to have a procedure. Our nephew, our niece, our neighbor's son or daughter. Wait a minute. Now let's be careful we don't interfere with employees' right to take FMLA. How about something more appropriate, such as, I'm confused, help me understand, because FMLA typically is not for our neighbor's children or our nephews or our nieces. And this, when we can give that opportunity to the employee to explain, for example, I know, however, this child that I'm taking care of, their parents are not in the picture, are in jail, or they are out of the country indefinitely. So I'm taking care of this child. It doesn't matter that they don't have legal documents. They are acting as the parent. Now, a lot of employers, they ask me, can the employers ask for any type of documentation so the employee can prove that in loco parentis relationship? Yes, absolutely. You as the employer, you have the right to ask for documentation so they can prove this in loco parentis relationship. However, the employee is the one who is going to choose what type of documentation they will provide to the employer. So the employer has the right, they are not interfering with FMLA if they ask the person to demonstrate something that they are acting in loco parentis for this child. But it's going to be the employee's choice on what to present to the employer. And this requirement can be met simply by having the employee write in a piece of paper, in a note, that they're acting as the parents to this child. That should suffice this requirement. We are not going to play FBI. We are not going to say, oh, no, you need to provide me birth certificate. Oh, no, you need to provide me court documents. No. Then you'll be interfering with an employee's right to take FMLA. There are different ways on how employees can take FMLA. We got the continuous leave. Continuous leave. This is when employees need to take FMLA on a continuous basis. They need to be out maybe for 4 weeks, 6 weeks, up to 12 weeks in a 12-month period. Maybe the employee is going to have procedure, surgery, or the employee's family member, and then they're going to need a lot of weeks for recovery. So that will be a continuous leave. The employee is going to be out for a specific amount of weeks. They're not going to be coming back and in and out. No. They're going to be going out and they may come back, whatever it is, 6, 8, 10, 12 weeks. That is a continuous leave of absence. Now, who is going to determine and decide how the employee is going to be taking FMLA? This is going to be determined and certified by the employee's physician, by the employee's healthcare provider. So the healthcare provider will tell you in the certification form, this person needs to be out from this day to this day. That's going to be a continuous. Employees also could take FMLA in what is called an intermittently basis. What is intermittently basis? An intermittently basis, think about when like somebody suffers of maybe migraine headaches. They're unpredictable, right? So maybe the employee woke up this morning and had a migraine and contact the employer and said, oh my God, I have such a bad migraine. I just took my medication. I should be there at work in a couple of hours. Okay, and they come to work. Then tomorrow, Thursday, they're doing okay, but then around 12 p.m. when they're at work, they get a migraine. And they said, oh, I need to go home. This migraine is really bad. And then it happens that on Friday morning, again, they wake up with a migraine and they collapse for the day. So that's going to be on an intermittent basis on separate blocks of time. Yes, the employees can take FMLA on an intermittent basis if this is certified by the employee's healthcare provider. And another way that employees can take FMLA is what we call a reduced schedule leave or a reduced schedule basis. This is when the employee, due to the employee's own serious health condition or due to the employee's family member with a serious health condition, the employee is going to be instructed by the healthcare provider that they have to work less hours than what they are regularly scheduled to work. For example, you may get certification form that says for the next 3 months, the employee cannot work more than 5 hours per day and no more than 25 hours per week. There you have it. So that would be a reduced schedule. The healthcare provider is saying that the employee cannot work complete schedules, that they are reducing their hours for maybe a temporary period of time. Maybe again, for the next 3 months, the employee can only work up to 5 hours per day, no more than 25 hours per week. But please remember, this is going to be determined by the employee's healthcare provider, how the employee needs to take FMLA. Now, when we mentioned that FMLA eligible employees can take up to 12 weeks of FMLA during a 12-month period, and for military caregiver leave, that they can take up to 26 weeks in a 12-month period. How do we track that 12-month period? Up to 12 weeks in a 12-month period, up to 26 weeks in a 12-month period. Well, what is that 12-month period consist of? Well, there are 4 different methods that employers can use. Employers can choose which method they want to use. And once the employer has a method, they could change it if they want to. But when they're going to make a change on how they are tracking the 12-month period, they need to provide to the employees a 60-day written notice that we are going to be changing how we track the 12-month period. So these are the 4 different methods. One is called calendar year, and this is a very simple method. Calendar year. So this is when the employer says, employees, a 12-month period for you to get 12 weeks of FMLA in a 12-month period. It starts January 1st and ends December 31st. That is the 12-month period. You can take up to 12 weeks in a 12-month period between January 1st and December 31st. Other employers that we use what we call any fixed 12-month period. Any fixed 12-month period. Some employers may want to use maybe instead of the calendar year, maybe they will use a fiscal year. Maybe they will use the employee's anniversary date of hire. Any fixed 12 months. Other companies will use what we call the rolling backward method. And other employers will use the rolling forward. So what's the difference? Rolling backward. Well, today is when I'm doing this recording, because I actually did the live recording this morning and I forgot to record it. So here I am again, recording it for the second time with no audio. But anyways, my mistake. Need to be more careful. But anyway, as of today that I am recording this, today is November 20, 2024. So when a company is using the rolling backward method, we go back 1 month back. So we're going to go back to November 20, 2023 till today, November 20, 2024. That's the 12-month period. That's the 12-month period. November 20, 2023 to November 20, 2024. Employee, this is when you can use your 12 weeks. Very confusing method, the rolling backward. Very confusing. Now, let's say an employee comes today and says, I need to take FMLA. Effective today. Okay. Sometimes they're not going to get any previous notice from like I don't know, the healthcare provider. Oh, you need to bring your spouse today. We're going to do the surgery. So we need to prepare him today for surgery tomorrow early in the morning. Okay. So you maybe use the rolling backward method. Okay. So you look back from November 20, 2023 till today, how many weeks the employee have used of FMLA? Oh, employee, you use already 10 weeks. 10 weeks in that 12-month period, November 20, 2023 till today, you already used 10 weeks. So you only have 2 weeks available. Oh, but hold on. I see that in November last year, you took 1 week of FMLA. Okay, so that was on the last week of November. Okay, so on the last week of November, you're going to recover that week of FMLA. Oh, look, December last year, you used 2 weeks of FMLA. Okay, then December this year, you're going to recover those 2 weeks. So you always look back 12 months, and the employee will only have whatever they have in use from their 12 weeks in that 12-month period. And then there's another method, which is the rolling forward method. So instead of looking back 12 months back, we're going to be looking forward 12 months. So employee needs to take FMLA effective today. So what are we going to do? Okay, then we said today is November 20, 2024. Okay, employee, you have 12 weeks that you can take of FMLA from today until November 20, 2025. That's the 12-month period from today up to 12 months from today. So employers, again, are going to choose which method they are using, and they need to let the employee know in the employee's rights and responsibilities which method you are using. And yes, like I said, employers can change their method, but they need to make sure that they give the employees at least they need to give at least, 6 months period to let them know. I'm sorry, what am I saying 6 months? A 60-day written notice that you're going to be changing the way that you track the 12-month period. Okay, what else? Let's look at employer responsibility notification. Number 1, you need to have a poster that is going to be displaying the Department of Labor FMLA poster in a visible location in every single site that you have, in every single location. Even if you say, but I do not have any employee yet who meets FMLA eligibility requirement. You still need to have that FMLA poster. Now, when an employee lets the employer know that he or she has an FMLA qualifying event, we employers, we have responsibilities. We gotta provide certain paper forms. We gotta provide in some forms that we need the employee to have their healthcare provider complete. But here's the thing, when an employee requests time off on their FMLA, the employee doesn't have to mention, I need FMLA. They don't have to mention that. The request could be something as simple as, my father is sick. I need to go to Guatemala and take care of my father. The employer, which is not just HR, the manager, the employee supervisor, needs to be able to recognize that this was an FMLA request. My father is sick. I need to go to Guatemala to take care of him. That is an FMLA request. From that moment that the employee made that FMLA request, we employers have the responsibility to be in compliance with FMLA. We have the responsibility, the obligation to provide paperwork to this employee. Gotta provide them within 5 business days. Within 5 business days, we are gonna provide them eligibility notice if they meet FMLA eligibility requirements or not. Rights and responsibilities for the employee, and the certification of healthcare provider. If the employee is asking for FMLA for themselves, then we provide the form from the Department of Labor, WH-380E, E for employee. That's the certification of healthcare provider for an employee's own serious health condition. If an employee is asking for FMLA for a family member, then we are going to provide to the employee the Department of Labor FMLA form WH-380-F. F for family member. So we got to provide eligibility notice, rights and responsibilities, and the certification of healthcare provider to the employee within 5 business days from when they notify the employer that they have an FMLA qualifying event. From that moment, we have to give the employee 15 calendar days. We gotta provide them 15 calendar days for the employee to have the healthcare provider complete that certification form. If that certification form is completed and the employee brings it back to the employer, we need to review it to make sure that it is complete. If it's not complete, some questions were not answered. Some answers are very vague, unresponsive, such as indefinite, unknown, unpredictable, as medically necessary. No, we are not going to accept something that is vague. So we are going to give this back to the employee, letting them know in writing what is missing. And we're going to give the employee an additional 7 calendar days for the healthcare provider cure the deficiencies, add what was omitted on the form. We have to give them, by law, 7 additional calendar days. Now, when they bring you back the certification form, if it is now completed in its entirety, then within 5 business days, we need to give the employee, we need to give them the designation notice. This is when we're going to say, employee, your FMLA request is being approved. Or employee, your FMLA request is being denied, and this is the reason why. We have responsibilities. We also have the responsibility to track their FMLA leave. Gotta monitor. We gotta track to make sure that employees are taking FMLA within the time that is allowed by FMLA. Remember, up to 12 weeks in a 12-month period, or for military caregiver leave, up to 26 weeks in a 12-month period. We need to make sure that we're using a consistent method to calculate the 12-month period, right? This is when we look, do we use the calendar year? Do we use any fixed or any set 12 months? Do we use the rolling forward? Do we use the rolling backward? And we need to apply it uniformly. So that means that, no, we're not going to be using one method for one employee, a different method to another employee, a different method to another employee. No. Remember, the only method that you will use, which will be different from the method that you always use, is only if the employee is asking for military caregiver leave, because that one always you have to use only the rolling forward method. We also got to track intermittent leave. When the employee is calling out and saying, I'm going to be, maybe they're calling for late. I'm going to be 2 hours late because of FMLA. I have a migraine. Or they're leaving early 2-3 hours. Or they call out today for FMLA. It needs to be reported. And you need to have your FMLA specialist, whoever is handling FMLA, to track every single hour that the employee is using as FMLA. And I'm going to say that's usually when the nightmare happened. I love FMLA. People think that I'm crazy when I say I love FMLA. They say, Elga, nobody loves FMLA, but I do. I do. What I don't like is the tracking. No, that I don't like. Okay, FMLA employer responsibilities compliance. So there are two, as I mentioned, two FMLA claims that we need to avoid at all costs. And those are interference claim and retaliation claims. We cannot interfere with an employee's right to take FMLA. Like if we tell the employee, no, I'm sorry, I cannot allow you FMLA right now. Yes, you meet the eligibility requirements, but guess what? No, right now it's really busy. No, you're interfering with the employee's FMLA right. If they meet the eligibility requirement, if they have the paperwork, we cannot interfere with employees' right to take FMLA. And also, we cannot retaliate. If an employee takes FMLA, we cannot take an adverse employment action, such as, oh, because you're taking FMLA, I'm going to have to give you a demotion. I'm going to cut your hours. I'm going to reassign you to a less desirable position, or terminate the employee, or give a negative performance evaluation because they're using a lot of FMLA. You don't count FMLA absences on your attendance policy. We cannot retaliate. An employee asks for FMLA, and then we turn around and we terminate them. That's retaliation. So we cannot retaliate. We cannot interfere with employees' right to take FMLA. We need to make sure to be in compliance that we're keeping our FMLA records for at least 3 years. This is what is required by the Wage and Hour Division of the Department of Labor. We gotta keep payroll records and FMLA records for 3 years. We gotta provide training to our managers, to our supervisors, to ensure that they are consistent on how they are handling and applying FMLA, which is the law. And yes, you want to get medical certifications to ensure that we have a process to be able to know when we are going to be able to deny or when we have to approve FMLA. Okay, I have several scenarios that I have ready to cover, but even on the live session that I did today, I couldn't get to all these scenarios. Okay, but we'll cover one, and I'm going to promise if you are listening to this recording that I'm going to go and cover the other scenarios, but they're going to be included in a blog. So I have a lot of blogs in my website, right, where you're finding these free resources, which are the recordings, because I'm committing every single month to do a free complimentary webinar. I'm going to try to be doing this on the third Wednesday of every month at 11 a.m. to 12 p.m. Eastern time. So I will be adding those scenarios that I'm not going to be able to finish here in blogs, but we'll go over this one. So this is navigating post-FMLA challenges, navigating post-FMLA challenges. So the scenario, balancing ADA accommodations and business needs. Scenario is an employee has taken the full 12 weeks of FMLA leave due to a serious health condition, recovery from major surgery. Shortly before returning to work, the employee informs their employer that they have developed a related condition that substantially limits a major life activity, mobility impairment, and requests an additional 8 weeks off to recover, citing the Americans with Disability Act, ADA. Well, the employer is uncertain how to proceed, as the FMLA entitlement has already been exhausted. Remember, the employee already used the 12 weeks of FMLA that he or she is able to take in a 12-month period. The 12 weeks of FMLA are exhausted. But according to the employee, their physician is saying that they still need to be out for 8 more weeks. What do we do? And what we don't do? A lot of employers are going to be pushed, sometimes by managers, supervisors, executives. Oh, this person was supposed to be here on Monday. Today is Wednesday, and they haven't returned from FMLA, and they already exhausted FMLA. You need to terminate this employee. No, don't terminate that employee. You could end up in a huge retaliation case. Don't terminate the employee until you know what is the reason that the person needs to be out. If the person, after exhausting FMLA, the person still needs to be out, but it's due to a disability protected under ADA, you're going to engage in the interactive process. You're going to ask the employee for documentation from the healthcare provider certifying that the employee still needs to be out for another 8 more weeks. If allowing these 8 more weeks to be out is not going to cause an undue hardship to your company, to the company. When we talk about undue hardship, we don't say, oh, it's going to cause an undue hardship in the department. Oh, it's going to cause an undue hardship to the building, to the location. No, it has to be that it will cause an undue hardship to the entire company. Very difficult for medium-sized and large-sized employers to prove that undue hardship defense. We need to have an accommodation mindset. An undue hardship is defined as something that is significantly expensive that you, employer, you're not going to be able to provide that reasonable accommodation because you're going to be able to prove, look, we don't have the funds to provide that reasonable accommodation. Difficult. But you're going to be able to prove that you don't have $200, $300 to accommodate these restrictions. Very difficult, right? Okay, so you will have to approve an extension on the leave of absence. However, those 8 weeks are not going to have FMLA protection because FMLA has been exhausted. Remember what is protected by FMLA? Job restoration rights, to be able to bring the employee back to the same or an equivalent position. Well, when we approve those 8 additional weeks, FMLA is exhausted, there's no job restoration rights. When the employee is ready to come back to work, you may offer them any open position that you have, even if that open position pays less. It's in a less desirable shift. You reassign them to a less desirable position, even if it pays less, even if it has less hours. You don't have to reinstate them to the same or an equivalent position because they already exhausted FMLA. That's one of the things FMLA is going to protect. The other thing that FMLA is going to protect is continuation of the group health insurance. So if the employee needs to be out for an additional 8 weeks, you don't have to keep the group health insurance. This will trigger COBRA. But the most important thing is just because an employee is not able to come back from FMLA, don't terminate without first knowing what's the reason why this employee have not returned from FMLA. So here's the wrong way to solve this case. Immediate termination. Terminating the employee immediately after FMLA exhaustion without considering their ADA rights is a violation of the law. Courts have consistently ruled that additional leave may be a reasonable accommodation under ADA. We cannot ignore the interactive process. The interactive process is going to be an informal but documented conversation that we, HR, we are going to have with the employee who needs that reasonable accommodation. Like the employee asking that they need an additional 8 weeks as a reasonable accommodation, then we need to engage in the interactive process. Failing to discuss the employee's conditions, limitations, potential accommodations, demonstrate non-compliance with ADA requirements. Imposing blanket policies, denying additional leave because of a rigid maximum leave policy. Like when you say, no, we do not provide any additional leave beyond the 12 weeks of FMLA. Cannot have that because that would be unlawful under ADA. So what would be the outcome if we handle this the wrong way? The employer terminates the employee immediately after FMLA ends, leading to a lawsuit. Don't terminate. The court finds the employer failed to meet ADA obligations, resulting in substantial damages, including back pay, emotional distress, attorney's fees, and potentially punitive damages. The right way to solve this case: engage in the interactive process. Upon learning of the new condition, meet with the employee to discuss their limitation, needs, and expected return to work date. That's what we mean when we say we need to engage in the interactive process. We're going to meet with the employee. We're going to have an informal conversation, but please note that this informal conversation needs to be documented. You know, in HR, if it's not documented, You know, right? It did not happen. Request medical documentation to verify the ADA qualifying condition and the need for additional leave. Just because the employee says, my physician says that I still cannot come back to work, well, we need to get documentation stating that. Evaluate the accommodation request. Determine whether granting the additional 8 weeks of leave will impose an undue hardship on business operations. Every time an employer uses the undue hardship defense, they cannot just say it. Oh, is this significantly expensive? Oh, no. They're going to have to prove that. They're going to have to show their bottom line. They're going to look at how profitable this company is. Come on, this company made $5 million last year. And you're going to tell me that they cannot provide a $1,000 reasonable accommodation? And I don't know why employers always think that reasonable accommodations are going to be very expensive. I provided a lot of reasonable accommodations when I work with close to 400 individuals with disabilities. Sometimes the accommodations, most of the accommodations will cost me less than $100, less than $100. Evaluate the accommodation request. Determine whether granting the additional 8 weeks of leave will impose an undue hardship on business operation. Consider alternatives. Explore other accommodations if additional leave is not feasible. Maybe part-time work. How about remote work? How about reassignment to a different role? So this will be an example of the outcome if we handle this scenario the right way. The employer grants the additional 8 weeks of unpaid leave, finding that it does not cause undue hardship. And the employee returns to work on the agreed upon date. This resolution complies with both FMLA and ADA, prevents legal actions, and fosters a supported workplace culture. Anyways, I'm already 9 minutes over, more like 8 minutes over my live session that I had this morning. So what I'm going to do is with the other scenarios, like I promised this morning, I'm going to include them in blogs. Okay, so you can go into our website and I'm going to be adding these scenarios. They're very, very good cases of how to handle difficult scenarios. This is the costly consequences of failing to notify and protect employees' rights. Like somebody goes out because of a medical condition, and we do not provide FMLA. Ooh, interfering with the employee's right to take FMLA. Then we have another case, the employee refuses to use FMLA. So they have an FMLA qualifying event. We offer FMLA. They don't want to use it. They only want to use their PTO or their sick days. Ooh, what do? Do we designate the leave as FMLA? Do we just use the employee's sick days? Pros and cons. So I'll be also writing a blog on this. And then here was another one that was provided by one of my clients, one of my participants. I'm going to give you the credit, John Malady. So this is while an employee is out on FMLA, can they work for another employer? Very interesting. Okay. I also had another, we actually have 4 questions from John. Thank you, John. I'll be using them for blogs, like I mentioned. While an employee is out on FMLA, can they work for another employer? It depends. It depends on, you will read this on my blog. There you have it. I'm gonna just mention, if you want to become an expert with FMLA, our next today, FMLA ADA certificate program is going to be on December 5th and 6th. That's our next FMLA ADA, PDA, PWFA. So think about how much information I was able to provide to you in just 1 hour, in 11 minutes already. So imagine how much information I can provide you on 8 hours on FMLA and 8 hours on ADA. So you want to become that expert and start next year with that expertise to handle these difficult scenarios? Well, just look at in our website, hrtrainingclasses.com. Look at all the different certificate programs that we have, including this one, which is one of our best sellers. With that said, all I have to tell you is thank you so much for taking the time to listen to me. Thank you, thank you, thank you from the bottom of my heart. And I do hope that you continue joining us on these complimentary webinars. If you cannot join us, you can always read. We're going to be putting these webinars as free resources in our website. And also, please read all these different blogs that I'm putting in there. Don't forget to follow me on LinkedIn. And I really hope to see you in one of our certificate programs. Thank you so much, everyone. Enjoy the rest of your day. Bye. Thank you, thank you, thank you.